Hi, everybody, it's Kirk, and today I want to talk about something that's very important, a hot topic right now with federal employees, and also really with non federal employees. But of course, on this channel, I tend to focus on federal employees more than anything, and that is the federal government as an employer, their obligation to provide employees with a reasonable accommodation. Reasonable accommodation is a hot topic, but many times people do not understand what reasonable accommodation means. So, first, where did the term originate? It really originated in the U.S. in a law called the Rehabilitation Act. That law was passed in the 70s and provided that federal agencies, employers, were not allowed to discriminate against employees due to their disabilities and were also required to provide them with a reasonable accommodation to do their jobs. That law, the Rehabilitation Act, later became the model and the basis for the Americans with Disabilities Act, which was then passed in 1990s. So it is a law that really has had a wide-ranging impact on employment in the U.S. But again, we're going to focus just on the Rehabilitation Act. Now, if you were wondering under what circumstances you can get a reasonable accommodation, I do want to point out that there are maybe two other times legally when you could get a reasonable accommodation. One would be under Title VII because there is a provision of Title VII for religious discrimination that a federal employer must accommodate your religious practices. So that is an accommodation provision. It's generally not as broad or as widely accepted in its broadness as are the terms of the Rehabilitation Act. The second thing is passed in 2022 and effective in 2023 is the Pregnant Workers Fairness Act. That prohibited employers, including federal employers, from discriminating against employees based on pregnancy and also required them to provide pregnant employees with certain accommodations. And that would include not just while they're pregnant, but accommodations for those conditions that were related to pregnancy and to childbirth. Today, we're only going to be focused on the Rehabilitation Act and what it requires. So let's walk through and see what we can find out about the Rehabilitation Act and the requirement that they provide an accommodation to you. First off, it's very important to remember that to be entitled to a accommodation under the Rehabilitation Act, you must have a disability as defined by the Rehabilitation Act. If you do not have a disability as defined by the Rehabilitation Act, then you are not entitled to an accommodation under that law. This is very important because I often see folks who have been diagnosed with a disability or determined to have a disability under some other law who are saying, hey, Kirk, based on this, I've already shown that I have a disability. Common things would be folks who have disability ratings through the VA or have disabilities related to a prior on-the-job injury or something along those lines. Now, while those people may also qualify as disabled under the Rehabilitation Act, you've got to remember the Rehabilitation Act has its own definition, and to take advantage of its protections, you must meet those terms that are in the Rehabilitation Act. Now, not that it's specifically in the Rehabilitation Act, but just kind of how I like to think about things, disability can really have three meanings in my mind. You can have a physical disability, you can have a mental disability, or an emotional condition that is a disability. So I like to talk about all three of those things when I'm talking to employees, although realistically, when we are litigating these cases, it really doesn't matter. It only matters do you meet the definition of disabled under the Act. It's important because oftentimes people will think, well, hey, I've got this condition. It's a mental condition or emotional condition, whatever the case may be, and therefore it is not a disability. That's not the case. So we're not just focused on physical disabilities when we're talking about the Rehabilitation Act, but also mental and what I refer to as emotional conditions as well. Now, If you can establish that you have a disability under the Rehabilitation Act, your employer, your federal agency, would be in violation of the act if they discriminated against you because of your disability. So think about it this way. If they refused to hire you because of your disability, if they removed you from your job solely because of your disability, if they denied you a promotion because of your disability, then there would be a violation of the Rehabilitation Act. It would be the same with the Americans with Disabilities Act. But they also would be in violation of the act if they refuse to give you that reasonable accommodation, because that affirmative part of the act, that they have to do these things for you, is required. And if they don't do that, then they have violated the Rehabilitation Act. But going back to our analysis, if you prove that you have a disability under the Rehabilitation Act, the next step is to show that that disability in some way interferes with your performance of your job. And if you've shown those two steps, you are well on your way to showing potentially an entitlement to a reasonable accommodation. But the next step is the step where it can be tough for some folks and a little dangerous. The third step in this process is to show that your disability interferes with your work to the extent that because of the disability, you cannot perform one or more essential functions of the job. So the disability law is really focused on you performing the essential functions of your job. And if your disability is impacting the job and impacting the essential functions, then you are not able to complete those essential functions, and therefore you would need a reasonable accommodation. Something very important to think about here. If this is focused on essential functions of your job, and you are not able to perform an essential function of your job, you will be later on in litigation tacitly admitting, I could not do my job without the reasonable accommodation, right? So the idea, though, is that you would be requesting the reasonable accommodation to allow you to perform the essential functions, but just an accommodation for those essential functions, whether it's one or more than one, that you cannot perform because of your disability. But you do kind of have to make that decision and move forward. Is this a discrimination issue where I'm only going to focus on the fact that the agency is treating me differently because of my disability? Or is this one where we're focusing on the fact that you need an accommodation to complete those essential functions? Because again, the distinction here is if you do need that to complete one or more of the essential functions, you're admitting without it, I cannot do that. The issue then, legal issue, becomes if you cannot do that part of your job, and the agency does not have to, for legal reasons, medical reasons, whatever, provide you with a reasonable accommodation, well, then you can't do your job, right? Because you can't perform that essential function of your job. So we oftentimes have to kind of keep that in mind as we move forward, that we are in a way admitting that we can't do the job without the reasonable accommodation. And if the agency doesn't give us, we will not be able to complete that. So it's very important to kind of keep those things in mind as we move forward. Now, pursuant to the law, the agency must give the employee clear instructions on how to request a reasonable accommodation, and once the employee has complied with those instructions, to then give a specific response in writing to the employee. Now, one of the questions I often run into with employees is, how do I make a request for a reasonable accommodation? Under the Rehabilitation Act, same under the ADA, the way that you request a reasonable accommodation is not really technical. It's not a specific technical way that you have to do it. There just has to be some portion or some way for you to indicate to your employer that you need the reasonable accommodation. So it is perfectly fine under the Rehabilitation Act and the ADA for you to verbally request a reasonable accommodation from a manager, from human resources, or from a division or committee in the agency that is in charge of being able to grant these. But oftentimes folks don't realize talking to your supervisor and asking for an accommodation, that is a request for a reasonable accommodation, as long as there's enough information in there for the for the supervisor to know that you may have a disability and that you may need a reasonable accommodation. You can also request those in writing as well. So you could send your supervisor, for example, an email saying, "Hey, I have this condition and I'm not able to do my job. I have this condition. I need a reasonable accommodation," whatever the case may be. And then every agency is going to have a formal way that you request it, right, in writing. And most agencies, once you request it verbally, then they're going to send you the paperwork for you to complete. And it may not be hard copy paperwork anymore. It may simply be on the computer where you complete it to give them the information that they will need. Then once they do that, once you do that, once you send the information to them or you make the request, then the next step in the reasonable accommodation process is to engage in what is called the interactive process. Now that and some steps after that are a little bit more than I wanted to get in for our initial overview of the Rehabilitation Act and how to request a reasonable accommodation. At least in this video, I will come back later on. We'll focus on the interactive process. We'll focus a little bit more on some of the issues related to it. So if you enjoyed this, please like and subscribe to the channel so that when I post those other videos about the Rehabilitation Act, about disabilities and reasonable accommodation, you'll be sure to get those. Thank you all for watching today.